Thank you very much. Minister, I was quite surprised to not even hear you deliver remarks to kick off this pre-study, being as we're doing a pre-study. So because of that, we haven't had one speech delivered in the Senate by the sponsor of the bill, the critic of the bill, or the government, which typically happens. And now we don't have any remarks from you. That puts us in quite a tough spot when we're trying to actually analyze a complicated bill like this. But with that in mind, I'll start to say that your government's bill C-16 proposes to introduce what you call a safety valve on mandatory minimum sentences. But since this would allow judges to ignore Parliament's will and give inappropriately light sentences to serious criminals, I think it's more accurate to actually call this an escape hatch. There's nothing safe about this for victims of many horrific crimes. Minister, your bill C-16 would allow judges to ignore almost all mandatory prison sentences in the criminal code, including on convictions for aggravated sexual assault with a firearm, human trafficking, extortion with a firearm, drive-by shootings, and multiple other firearm offenses. How can you possibly look at victims of those terrible crimes in the eye and tell them that your escape hatch keeps them safe?
Mr. Chair, thank you to the Senator for her question. If Senators so desire, I'd be happy to take 5 to 7 minutes to deliver a set of opening remarks to summarize the bill. I trust members of the committee are well aware of the issues and have put my position on record in the House and before the Senate during question period, though not specifically on this bill, including on this bill amongst other items. I fundamentally disagree with the characterization of mandatory minimum penalties as discussed by the member and the characterization of the provisions that exist in the bill. Obviously, the provisions that do not include some residual discretion in the form of the safety valve envisioned by C-16 have been deemed routinely unconstitutional by the Supreme Court of Canada. If we want to feel good about the words that are included in the code, knowing that they have no legal force and effect, the Constitution, or rather the laws that have no constitutional validity would not be worth the paper on which they are written. The measures that we're putting in place restore mandatory minimums, but respect the constitutionality as outlined by the Supreme Court of Canada. This residual discretion, I would remind Senators, only applies in circumstances where the proposed mandatory minimum would be grossly disproportionate. In addition to taking guidance from the Supreme Court's decision, this mirrors the position that was put on record by the Conservatives' public safety critic, Mr. Caputo. It reflects the perspective of my Bloc Québécois critic, Mr. Fortin, and seemingly has a broad base of support across not only parliamentary representation, but from the direction of the Supreme Court as well. My view is that the laws that we adopt should be constitutional, that they should have the force and effect of law, and we have corrected a constitutional challenge that courts have routinely pointed out as rendering existing mandatory minimums of no force and effect.
Minister, that comment you just made does not accurately reflect the position of Mr. Caputo, actually, but I'll move on. Saskatchewan's Justice Minister Tim MacLeod provided our legal committee with a substantial brief on Bill C-14, and in it he stated this, quote, while Saskatchewan acknowledges the proposed restatement of some struck-down mandatory minimum penalties in Bill C-16, that bill does not address mandatory minimum penalties that were repealed outright. Saskatchewan is particularly disappointed that mandatory minimum penalties for drug trafficking, many of which were upheld as constitutional by the courts, were not reinstated, unquote. How do you respond to that?
Certainly, and first, my counterpart has been a tremendous partner on a range of different bills. You referred to C-14 in your question. I assume you mean C-16, but uniquely he's been helpful on C-14 as well. The strategy that we've chosen to adopt when it comes to restoring mandatory minimums was to look at those that have been struck down by the court and to protect those that were still on the book. You referred to the will of Parliament in your previous question. We decided to respect the will expressed by the previous Parliament when certain decisions were taken to remove some, but not all, mandatory minimums within the code. We sought to respond very distinctly to the Senville decision, but came to understand very quickly there was a number of other provisions that were not removed through a democratic process in Parliament, but instead through a legal process that is democratically recognized, of course, in the courts. Seeing that we had an opportunity to reverse the effect of having those mandatory minimums struck down that were not determined through democratically elected representatives of communities across Canada. We limited the scope of the restoration of those mandatory minimums to those that have been struck down and those that remained on the books today.
Second round, please. Thanks very much. Minister, I really appreciate the support that you're giving to Bailey's Law, and it's such a good cause, and I really appreciate your heartfelt comments about that. It's obvious that that is very sincere, and I too have been honored to meet Bailey's aunt prior to this, and then to see her again today was great, and to express support for this important bill in Senate chamber speeches that I've made about this topic. And yes, with that 1-year anniversary of Bailey McCourt's murder on July 4th fast approaching, I just want to be extra clear. Mr. Caputo introduced his private member's bill last September. Your bill C-16 was introduced last December. And I appreciate you saying that it's your view that these laws can run in parallel. So I just want to get the clarification. So in the event that both bills are successful and receive Royal Assent, you do then support, you would be fine with Royal Assent for Bailey's Law occurring before that tragic July 4th anniversary and prior to potential Royal Assent for Bill C-16. You think that that is absolutely correct?
Yeah, that causes me, first of all, I know there are things that you and I may not agree on. This is something we agree on, and I thank you for your comments in that regard. It is of no consequence to me if Bailey's Law receives Royal Assent before Bill C-16. These two are not in conflict. Despite the fact that C-225 was advanced first, there was a common campaign commitment that we had met. I met with Mr. Caputo. I met with family members. We worked very closely in preparing the amendments to the initial draft with our office. It's been deeply considered by officials within the Justice Department. We want it from the moment we understood there was an opportunity to have an impact to get this right and to move forward. It does not matter to me, and I don't think Canadians much watch which bill goes first, but it means something to the family. And if that's something that we can accommodate, it's of no consequence to me if one bill precedes the other. If it's a nice gesture that we can offer, it's in response to such a horrific tragedy. Please know that from the government's perspective or from my office's perspective, there's no effort to have C-16 go forward for political reasons. If the Senate has an opportunity to achieve that outcome, I'm not in control of your processes, but no, that causes me no problem.
And as someone who understands the importance of a legacy for the death of a loved one, absolutely that will be a very meaningful gesture and an important change to the law. Thank you.